I apologize. Before we adjourn, we do want to open it up. We have public comment on the agenda, so I apologize. Yeah, please approach. You were so patient. I could never forgive myself if I...
Thank you. I did drive 3 hours to do it. So I'm Benjamin Cohn. I'm a disability rights attorney from Mountain View. And you heard and just addressed the request for funding. I think that residual boondoggles aside, they probably do need more funding, but it should be conditional. There's a lot of issues that need statutory oversight as a condition of getting that funding, reapproved, increased, or whatnot. One I particularly wanted to address is testing accommodations. They will tell you that they are addressing it, that they have a rules revision initiative in progress out for public comment, but that is belied by two problems. One, the rules revision initiative, even in its current form, does not address most of the problems, such as response times and deadlines to seek appeal that provide procedural equal opportunity even when all the accommodations are granted, among other procedural issues that I believe currently violate the ADA. And the other problem is that even that was a response of hundreds of people from about, I think, 78 organizations or groups or coalitions of public comment opposing the initial genesis of the Rules Revision Initiative of admission staff trying to use that as a pretext for things that would reduce their workload, and the original version had actually made the rules even more discriminatory. It's also undermined by the fact that as this revision is being done, the state bar is in the Ninth Circuit challenging the constitutionality of the ADA and saying that it does not require any procedures as to timelines for making a decision on a request, how much explanation must be given about the reasons for a denial, what procedural requirements are in place to receive requests, and how the request decision-making should be adjudicated internally, which a belief about the ADA is really reflected in the current rules and in the continuing defects in the rules that are out for public comment right now. And I hope that there will be statutory directives such as codifying some of the procedural reforms into the fee bill or the State Bar Act or however that should be done, and by clarifying that California civil rights law applies to all public entities, including the UNRU Act. Thank you.
Thank you. Any other members of the public who wish to speak?
Rebecca Marcus, representing the Consumer Protection Policy Center at the University of San Diego School of Law. I was looking forward to just letting Professor Felmuth know that I wasn't allowed to make public comment. I will highlight several of our recommendations to improve the state bar's protection of the public to now, and then provide further comments, written comments to the committee. We recommend that the bar puts in place interim remedies for cases that will likely take 90 days or more to complete. Such remedies should include requiring an accountant to handle monetary funds connected to questionable spending and concealment of client funds. In the Girardi case, this would have meant hundreds of thousands of dollars going to intended beneficiaries rather than to counsel. Other remedies could include the assignment of an independent counsel if the subject matter is complex and competence is at issue. There's a myriad of other possible remedies that may assuage continuing harm from negligent practice while the bar's investigation is underway. We recommend identifying all counsel with multiple serious complaints. These repeat offenders should be subject to a coordinated wholesale inquiry. Based on earlier testimony today, it appears that these efforts are already underway at the state bar. The legislature has rightly blamed the state bar for many failures. However, unless they provide adequate resources, we can't expect much improvement. When Professor Felmuth served as the discipline monitor, the annual fee for attorneys was approximately $410. 30 years later, it is essentially the same. Mere inflation would bring that to $900. Whether it's through a license fee or general fund, we have no opinion as long as the increase is earmarked for enhanced discipline. And finally, we support the recommendation that was brought up today by Assemblymember Pappen. She asked a question about MCLEs. We think that attorneys should be required to have MCLE credits in their area of practice. So a family law attorney should have credits in family law, bankruptcy, et cetera. So we look forward to continue conversations. Thank you.
Thank you, and please let my friend Professor Felmuth know I did not screw up public comment, so I don't have to hear from him. With that, I don't see any other members of the public that wish to speak. Seeing none, now I think we're safe, Mr. Chairman, on behalf of the Senate Judiciary and the Assembly Judiciary in concluding today's meeting. Thank you all for attending.